Good evening. Welcome to Left, Right and Centre. I'm Vishnu Shom. On the show tonight, the Supreme Court rules that there will be no legal gay marriages for now, but has stressed that an individual's right to enter into a union or relationship cannot be restricted on the basis of sexual orientation. Now, there were 4 separate judgments in the Supreme Court today with clear differences on the question of adoption rights for queer couples between the judges. While the order today is a setback for the ultimate goal of same-sex marriage, there has been unanimity on the need to address the practical concerns of same-sex couples. Ration cards, pension, succession issues and gratuity, those were raised by the Chief Justice. But it is the government now that will have to address many of the concerns I mentioned. For the moment, the court will not be doing that. Now, some of the statements of the Chief Justice, Justice Chandrachud, championed the rights of queer couples, making it clear that queerness was not restricted to the urban elite. The Chief Justice also said that there is no record available to suggest that only heterosexual couples can provide stability to a child, though ultimately Justice Chandrachud was in the minority on the issue of adoption rights for gay couples. What we'll do on this program is deconstruct the order today, look at the main points and look at where this issue is headed. Later on the show, my colleague Maria Shakil in an exclusive interview with the Israeli ambassador to Delhi, who makes it clear that the situation on the Gaza Strip cannot be resolved without direct intervention. But first, the landmark judgment of the Supreme Court on whether or not gay marriage can in fact be legalized. Here are some of the key points.
A setback for gay rights in India, as Supreme Court on Tuesday refused to legalize same-sex marriage. The 5-judge Constitution bench upheld the rights of queer couples under the existing laws, but refused to read down or read words into the Special Marriage Act, guaranteeing marriage equality. The court said that it's for the Parliament and state legislatures to enact laws recognizing and regulating queer marriages.
I'll begin by reading out some of our portions. There's a degree of agreement and there's a degree of disagreement.
Writing the minority opinion in the landmark case, Chief Justice D.Y. Chandrachud along with Justice Sanjay Kishan Kaul has held queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. It's in the domain of Parliament and state legislatures to enact law recognizing and regulating queer marriage. This court cannot either strike down the constitutional validity of Special Marriage Act or read words into because of institutional limitations. The state has an obligation to recognize unions of queer couples and grant them benefit under law. Unmarried couples, including queer couples, can jointly adopt a child. Government shall not discriminate against the freedom of queer persons to enter into union with benefits under law. The court asked the government to set up a committee to look into the practical concerns regarding benefits and services to the same-sex couples. Justice Ravindra Bhatt, who formed the majority opinion in the judgment, along with Justice Hima Kohli and Justice Narasimha, has held that legal recognition of rights to union akin to marriage or civil union or conferring legal status upon the parties to the relation can be only through enacted law.
Consistent with the statement before this court during the course of the proceeding, the union shall set up a high-powered committee chaired by the Cabinet Secretary to undertake a comprehensive examination of all relevant factors, especially including those outlined above. In the conduct of such exercise, the concerned representatives of all stakeholders and the views of all states and union territories shall be taken into account.
Solicitor General Tushar Mehta, who represented Centre in the case, welcomed the judgment, stating it balances the interests of individuals with interests of the society.
Supreme Court, while stopping short of legalizing same-sex marriage, has accepted the submission of Centre that a committee under Union Cabinet Secretary will be formed to define rights and entitlements for queer couple who are in union. With camera person Ashwini Mehra, this is Arvind Gunasekar for NDTV.
Well, joining us now, Dr. Abhishek Manu Singhvi, senior lawyer, Congress leader, Rajya Sabha MP, somebody who's legally represented. one of the petitioners in this case. Thanks, Dr. Singhvi, very much for being with us. Now, Justice Bhatt said that the court cannot create the legal framework for queer couples to get married, among other issues. While the Chief Justice said, and I quote, my learned brother acknowledges the discrimination against the queer couples but does not issue directions. I cannot come to terms with such an approach. Could you share with us your opinion of the contrast that we saw in the order which was passed today?
Vishnu, thank you. First of all, whatever I say, you can always understandably take with a pinch of salt, because I was the lead counsel for the petitioners seeking recognition of marriage, but of non-heterosexual marriage. But let me just start by saying that I must confess that I am very deeply disappointed. It's a historic opportunity missed. Now, just take the point you mentioned. The argument, the principal argument of all five, forget the difference between them, is that you cannot read into the SMA a constitutional compliant interpretation, which we said must be read into it to eliminate discrimination arising from what is ascriptive conditions. Ascriptive conditions only means, Vishnu, that you are really discriminating between persons on account of things like sexual orientation or gender, which is involuntary condition, not taken by choice. Now, this argument is met by saying it requires legislation. We cannot do judicial legislation. But tell me, Vishnu, the legislation they did when they decided the basic structure theory, is that not many times more a reading into a substantive doctrine than what we were asking for? Take, for example, when they read consultation, the word in the Constitution, to mean concurrence, and thereby made appointments of judges the sole prerogative of the Supreme Court. That was by interpretation.
Yes.
By reading the word. Now, what we are asking for, this was much lesser. Take the case, for example, of reading due process, substantive due process into Article 14, which was never there. In fact, the Constitution framers rejected it. So the point is that this is really a bit subjective, in the sense that when the Supreme Court is wanted, they have read much more into what we asked for. The very simple thing. In a SMA, you read the word husband or wife to include same-sex persons. That's not a very big leap for the judiciary to do. Point one. Point two is that you did not answer so many questions which we were raised. One was the ascriptive conditions question we raised, that it is discrimination based on conditions which are involuntary. But equally, you have not denied that there is decisional autonomy. You have not denied that there is right to privacy. You have not denied that there is right to decisional autonomy, etc. And yet you have not read this minimal into the SMA. Now, you have really salved your conscience by saying things like a civil union, or rather a union of two non-heterosexual people must get, recognition in terms of rights. There cannot be discrimination. There cannot be oppression.
Yeah.
But this is really not meeting the test at all. It is avoiding the question largely.
No,
and
but
I
sir,
feel
yes. You know what Justice Bhatt said, and this is about the Special Marriage Act. Now, you argued, the petitioners in this case argued, that the Special Marriage Act must be interpreted in a manner which is neutral to gender and sexual orientation. The Solicitor General had argued that tinkering with the Special Marriage Act can have a cascading effect. Now, in light of the majority order, what is the cascading effect that it can have that the majority of judges believe to be the truth?
I believe that the solicitor and the government of India successfully created a behemoth of public antipathy, which somehow pushed back, stopped in their tracks the judges who would otherwise have intended or wanted to do this slight interpretive leap, which is not a big leap.
Yes.
But there was a whole kind of hawwa, if I may say so, created about public antipathy. Now, your question has a very specific answer.
Yes.
What great distortion of the SMA are you doing by reading husband and wife to include same-sex couples? We said we don't want to get into religion. Today, the SMA is religion neutral.
Yes.
We said that we want only the minimal recognition by reading husband and wife, which marriage is registrable, to include same-sex marriages. Now, I do not see any insuperable leap of the faith in so reading it, except to say that, look, we are not legislators. We cannot do it through legislation. But then I've given you examples. You've done much, much more. When you read consultation to mean concurrence, it was a far bigger leap.
Sure.
When you created the basic structure doctrine, far bigger leap. So really, it's a value judgment. For some reason, the judges felt a little hesitant, if I may say, judicially fearful, somewhat restrained thinking that this whole thing is a huge public backlash, a chimera created by the government. Let me tell you one more thing. Most governments, including this one, would not be interested in doing anything resembling this recognition. To leave it to the legislature is to leave it to eternity. Now, it's all right, you can make some few guidelines saying that in the public space, I can't thrash you because you're a same-sex couple. You can make some rules saying that in a restaurant, there cannot be discrimination or a separate sitting space. You can make those, these are soft options. You should have taken the hard option.
So the leap of faith that you were hoping for, that many around this country were hoping for, clearly hasn't happened. But let me ask you this, sir. The Chief Justice, in his opinion, and this is important, and it as I understand it, has ramifications beyond this case. He said that the doctrines of the separation of powers and the doctrine of judicial review, right? He elucidated the doctrines of separation of power and the doctrine of judicial review. He explained both in fairly simple English. Now, how is this significant, not just in this case, but otherwise as well? And I ask this because there are some, and this has been the consistent line of argument of the government, saying that no, the judges, the courts cannot decide this. There are restrictions, limitations on what a judge can do.
I think.
Whereas he went into the separation of powers and said, no, in fact, the courts can do a lot more.
What I fault the other three is for not even doing the minimal judicial review, which you can do. What I applaud the Chief Justice is to go the farthest of the five and say judicial review is available, I can judicially review. But what I also fault the Chief Justice's judgment, along with Justice Kaul, is that they have not fully walked the talk after having found the power of judicial review. The power of judicial review is recognized, the separation of powers is not found to be an impediment, but then they have not walked the next step. As I said, there is no insuperable leap of the faith. On the contrary,
okay.
What you say, they did not take the leap. I don't think there's a big leap of the faith. It's a simple interpretive exercise by which you hold the words husband or wife or couples to mean same sex. That is, of course, an interpretation which is an advance in law that might be called by some a little more progressive than it should be. But there is not such an acrobatic leap which is not done. Much more acrobatic leaps are taken by judges.
All right.
And the Chief Justice recognizes the power of judicial
So bottom
review.
line, Dr. Singhvi, is that by pushing this
implementing
into the hands of the government, it is your fear that this is just going to be kicked down indefinitely, and that, no government may actually want to do anything about it.
The government committee is given very soft cosmetic options.
Is there a time-bound feature in this?
There is a time-bound feature in terms of constituting the committee. I don't see any time-bound feature in terms of implementing the entire package. And secondly, the package which will be coming out of the committee, you can take it from me, will be a very soft, ambiguous, very light-touch cosmetic package. It cannot be the hard-nosed, substantive thing. What are these people wanting ultimately? They are wanting that decisional autonomy, that dignity, that free speech and expression of their status as same-sex couples to be recognized in a marriage. Now that all the committees doing these things about, public places, discrimination, access. Of course, the Chief Justice did take a revolutionary step in terms of the adoption. I understand. But otherwise...
But the others didn't.
That will be treated as a minority judgment.
Just a final question before I go across to my panelists, Dr. Singhvi. In his, and it's a simplistic question, excuse me, the points mentioned by the Chief Justice where he's called for state governments and the centre to ensure that certain rights of LGBTQI members are protected, that is binding, right, irrespective of the fact that he has a minority order?
I would say so, because Justice Kaul expressly agrees. The other judges who form the three do not disagree. So I would say yes. But that is a very minimalistic, negative equality of a different kind.
Sure.
This petition is not about that. But yes, the answer is it is enforceable. You cannot harass a couple for being same-sex. You cannot say that because you are living openly as a same-sex couple, you'll be denied benefit of, let us say, tenancy or access to a flat.
No, but these are important steps, sir. For example, sufficient care has to be taken to cater to mental health. No one should be forced to go to hormonal therapy with respect to their gender. He issued directions to state governments to protect health and safety of same-sex couples. He has given benefits to queer couples such as ration cards, the right to nominate the next of kin. When we were looking at this earlier on, these were all points that members of the LGBTQI community insisted on.
Of course welcome. This is of course welcome.
And it is binding. It is binding, sir.
It is, I would say it is binding. There are people who would say that this is...
So how is that resolved? I understand your larger point, Dr. Singhvi, the larger goal has not been achieved. But how is this... Why do you say that there's a question mark on whether this can be adopted or not?
I'll tell you. The government is unlikely to contest this part of the Chief Justice's order as a minority and unimplementable. The government is quite happy to have a committee which will again ratify, repeat, reiterate these parts and make it part, because these are in a sense non-invasive. They are, according to me, minimalistic, and the government would be quite happy to achieve an equilibrium at this level.
Sure. All right, Dr. Singhvi, great speaking to you. Thanks very much. And I understand that, it's been disappointing to you. It's certainly been disappointing to many members of the LGBTQI community in this country. But I do believe, as a champion of rights myself, some of the observations made by the Chief Justice of India are far-reaching and perhaps give us, as Indians, a chance to reaffirm some of the finest aspects of our Constitution. Thanks, sir, very much for being with us. We're joined now by Shreyas Maheshwari, an associate at Karanjawala and Company, an advocate of one of the petitioners. Oneer, the Indian film director and author of I Am Oneer and I Am Gay. Zaina Patel is a transgender activist and also a petitioner in this case. Professor Geeta Bhatt joins us, as also Ashutosh Srivastava, who's a Supreme Court advocate. Professor Geeta Bhatt, one of the points which had been argued earlier on was that queerness was an urban or elite concept. I think it was the Chief Justice who emphasized, and I think it was backed up by the other judges, who said that queerness is not an urban concept or an elite concept. It is a concept. It exists. And there was an emphasis that the institution of marriage is not necessarily stagnant as a concept either, but it is, an ever-changing one. So while marriage for gay couples hasn't been accepted now, do you believe these statements, most of these came from the Chief Justice, are still important as we debate this?
Well, Vishnuji, yes, I do agree that we cannot distinguish between, the queer being a elitist or a rural concept. And definitely, I think the Chief Justice also mentioned that this has been, through the civilization, we have seen the existence of non-heterosexual orientations. It has also been illustrated by, Rishi Vatsayan while writing Kama Sutra. All this is very much, and I think that, in our society, the non-heterosexual orientation was very much accepted as a part of the society. It was not that ever there was any, from religious point of view, there was any kind of discrimination towards them. But at the same time, if we look at in terms of when we talk about a marriage between two individuals, then per se, we still cannot say that although it happens between two individuals, yet it defines the concept of being in the domain of the privacy of between two people, because there are consequences to it. Mm-hmm. And at this time, when we are discussing it, if we look at the United Nations General Assembly resolution, which defines how they define marriage, across the world they are still defining marriage as men and women of full age, without any limitation of race and nationality and religion, can go into a union. and they can form a family. So while the nature has created man and woman to procreate and to form a family, at the same time it is very much acceptable that there are exceptions in the society, and they are very well accepted in the society at the same time. But as far as the judgment goes, I think there are, as Mr. Singhvi was mentioned, my observation was that since when this hearing was going on and the petition was specially placed to make alteration in the Special Marriage Act. Now, yes, if you look at it in terms of Special Marriage Act, he mentioned that it is religion neutral. But if you look at it, there are mentions in Chapter 4 where it talks of consequences of marriage under this act. I do not have a law degree, but whatever I have read on it, there are observations where it says for example, effect of marriage on member of undivided family and so on and so forth, where Hindu Marriage Act has been mentioned. So while laws
so it has a cascading effect. That's what Justice Bhatt also said.
Yeah, just 10 seconds more. What I meant to say was that laws which are related to marriage and the rights which are subsequent to it, they are different, and also they are not uniform, because in this country we have an intricate mix of personal laws. And if we look at Islam and Christianity, their standing on non-heterosexuality is something which is very, very extreme.
Let's leave that aside, Geeta-ji, for just a moment. I just want to go across to Zainab. Zainab, there were important references in the order today which referred to transgender couples who adopt the role of a man or a woman. In other words, despite their being transgender, have in a sense a heterosexual association, and that is legal, right? Could you explain to us how that works, and is that something new, or is that something that's always existed?
So very quickly, Vishnu, in terms of what flowed from the Nalsa judgment today, Zainab Patel identifies as a woman. She has a legal document. There is nothing stopping me from entering into a heterosexual relationship where I identify as a woman with another man, or where someone identifies as a man and I identify as a woman. Now, this was upheld also in the Madras High Court judgment, where the court directed the registrar to register the marriage between a trans woman and her partner. But calling it loud in the Supreme Court judgment very prominently now paves the way, not only in the Special Marriages Act, but in the personal laws as well. Do we expect some kind of repercussion from religious group? Definitely. We've already seen a couple of negative reactions already in the press from religious groups. But I just look at it in this way, although there is no fundamental right to marry, but we do have positives, like trans people have the right to marry, the recognition of everyone to enter into relationships to be protected, and the need for an equality law. So I do see the positive side of it, but also the fact that what we have known and experienced and lived for a very long time, for trans people at least, there is supposed to be some kind of legal sanction now that there is an operative part of a judgment.
So that is important, isn't it, Zainab? Because while I understand that that gender and sexual orientation is entirely fluid, it's not black or white, the fact that there is now a categorical mention in the Supreme Court order saying that there is a possibility of marriage on the basis of the identity that you choose, as long as one partner is male, one partner is woman, is this not a workaround, and therefore one that protects the rights of trans people or gay people?
For a gay couple, yes, it does have implication, but for a lot of trans people who identify in the sense of gender, that this is a positive win. How we work around this for the larger community of non-binary identifying people is still piece and progress. I would leave that to the operative part once we are able to digest the entire judgment. I have just been able to see the last part of the judgment which calls this out, but I really don't have anything to comment till my legal team is able to put something more specifics into it.
Shreyas, one of the important parts of a part of the order, there were 4 orders, and this is what the Chief Justice said: to protect the rights of members of the LGBTQI community, the Chief Justice said that there cannot be any discrimination, sufficient care for mental health. He held that no one should be forced to go into hormonal therapy with respect to their gender. He issued detailed directions to the states to protect health, safety, etc., etc. He also gave benefits to queer couples, such as ration cards, the right to nominate next of kin. Right? Are these not landmark?
These are certainly landmark, and I would say let's not restrict to only Justice Chandrachud, but if you also go to Justice Kaul,
yes,
he also mentioned that there should be anti-discrimination law, which is again a very landmark statement made by the bench there. But in my personal opinion, I believe these things like gratuity, pension, employment, right to kin, medical practitioners will once ahead go to the panel which has been constituted, and the rights will flow from there. But the basic fact, the basic element of this being present in the judgment will have a major stakeholding, while these bouquet of rights which will be coming out by the panel will have a major holding.
Ashutosh, do you believe that getting laws through this committee, etc., in a finite period of time to ensure basic things like ration card, the right to nominate next of kin, who do you identify as a hospital attendant in the case of of two people in a gay relationship? These are basic fundamental rights or basic human rights, and therefore ensuring that it's there on a piece of paper would be very easy to ensure, would be relatively easy to implement.
See, the Supreme Court has recognized these issues which were raised in the petitions, and accordingly it has recommended for the high level committee who can prepare the draft and can recommend to the government for the formation of law. I feel the Supreme Court today has passed a very balanced judgment, and it has also respected the doctrine of separation of powers, and it realized that there is no scope to interfere into the preparation of a new law. And so far as the interpretation of the Special Marriage Act is concerned, it has gone deep into the details of the Act, and accordingly came to a conclusion that there is no such a scope for gender neutrality at present, which can be recognized by the Supreme Court. Yes, so far as the protection, dignity, respect of the community is concerned, the Supreme Court has passed numerous guidelines and has also given certain directions to the central government, to the state government, to the union territories, and also to the police department while dealing with such kind of cases where the two same-sex couple, if they are going out, or if any complaint is received, how those complaints are to be dealt with. If the consent of both of the members, it is there and they are going with their consent. So in these kind of cases where the violence or any sort of cruelty are exerted on these members of the community, how it has to be protected, how being the citizens of this country, their rights have to be protected, and they should be safeguarded. So
no, but Ashutosh, just one point of clarity, and I ask you as a lawyer, the Chief Justice, in his opinion, elucidated the doctrines of separation of powers and the doctrine of judicial review, and seemed quite categorically to suggest that the process of judicial review can happen nonetheless, that it is not enough to say that the separation of powers means that only the legislature can do something and the courts cannot touch that. He seemed to suggest that there is always scope for review, and therefore is that part of what he said, wasn't that something that the others accepted, and if so, is that not something which is binding?
See, judicial review was the matter. They reviewed judicially, and see, there can be different interpretation of the judicial review by different judges. That is why in these kind of constitutional matters, generally, number of judges, like 5 judges bench or something like that, is set up always, so that the interpretation of particular law can be made in a proper way. Whether the interpretation recognizes the prayer clause of the petitioners, or if it is something where the it will hamper the doctrine of separation of powers. And accordingly, the Supreme Court reached to such a conclusion with majority that no, we cannot interfere into the powers of the Parliament. Yes, once the law is framed, and if any part of the law is unconstitutional,
no, it was about interpretation. It was about interpretation.
Yes. I'm just explaining about the future aspect also.
Sure.
So that is how the Supreme Court or any court functions. Now, Supreme Court has not only given it to the Parliament at the to the central government, but it has also said that even the state governments have the powers. Even they can make laws for the state.
Yeah, but the Supreme Court retains the option of reviewing any aspect of what the legislature does. That was what the Chief Justice said, and as I understand it, none of the other judges disagreed with that. Right, but let's move on. Otherwise, Ashutosh, we can talk about this, at length, and it is fascinating. Onir, I think that the bottom line over here is that gay couples will not be able to enter a union of marriage. How much of a setback is that?
I think for me it was a landmark letdown, because I understand all the technicalities, listening to all the arguments, but when I look at you, I'm thinking that why is it that you are more entitled than me as a citizen in this country? Why is someone else more equal than me? And all the justifications, all the arguments fall flat, because I was thinking today when the judgment was coming out, all our life we've been watching movies where at some point a man or a woman proposes to each other, and I thought that maybe now after today's judgment that at 54 I would be able to ask someone, will you marry me? But I don't think that's a possibility. So I don't really care about all this legalities, whatever. I just think that being treated as an equal, being treated, having all the rights that everyone else sitting here, everyone else has, as a heterosexual, why should I be denied that as an equal citizen in this country? And even if I'm just one person, I need to be treated as equal, and this is a big disappointment.
Geeta, how do you answer something like that? You and I can quote the Supreme Court order chapter and verse, but Onir is a human being and an Indian just like we are, and if he says that why is it that you on this panel have more rights than me, how can we deny that? The fact is that we do, on the basis of our orientation. Doesn't that sound terribly unfair, Geeta?
Well, Vishnuji, see, there are various such issues which are still there. Although as per Article 14 and 15, we all have equal rights and equal rights to fight discrimination. But we do realize that even today there are women who don't have equal right to property. We are citizens of the same country. So these there are certain inequalities which are there in the society, but at the same time I think it is there is a sensitivity towards the non-heterosexual orientation, people who have non-sexual orientation. We need to work on it more in the society. The discrimination which as and when, if it is existing anywhere, that needs to be taken away. The government needs to come out with certain working part where the issues which are related to them having some kind of a protection which at times they have been facing, that it is not there, that needs to be worked upon.
Sure.
So I think the government has agreed to form a committee and look into various aspects of which I think will make Mr. Onir more comfortable.
Well, I certainly hope that this is progressive, and it isn't limited to just some sort of a soft solution, that there is something really tangible over there. We've done an entire debate on this, and we've not even gotten into the issue of adoption. Just look at the number of issues that exist. But I suppose we'll return to look at the entire issue of of adoption that has been denied to gay people, and the significance of that and the arguments which have been raised. But for now, we're going to take a short break. I'd like to thank you all very much for being with us.